Okay, very good evening to ladies and gentlemen. Welcome to my class. Thank you for being here today. Today we'll discuss evidence paper, November 2023 paper. Evidence is not a killer subject for your information. Most of the people will end up fail in their PP paper. But having said so, you cannot be very careless in answer this evidence paper as well, because as you all may already know, the threshold for you to pass this professional examination is very high. Okay, first and foremost, let me just do a few disclaimers. I'm just a very junior lawyer. Okay, there is no guarantee as to the quality of this teaching, as always, because I'm not a professional teacher. All right, and as you all know also, this is just a sharing session, and uh, LPQB by today, they did not provide any formal endorsement towards any sort of notes or what we call Q&A that is in the market. So therefore, there's no guarantee as to the accuracy of this answer. And last but not least, this does not serve as an academical reference. Okay, very important for you to realize that. Okay, without wasting time, because today we are going to discuss 4 questions. Okay, I plan to do it within 1.5 hours. So therefore, if you do not understand, you can always stop me, but maybe I'll try to answer the question at the end of the session. Okay, we go to the first question. Daniel is charged with the murder of his wife, Betty, by pushing her to death from 39th floor of their penthouse balcony at the Skyfall condominium. So Daniel maintains that Betty had committed suicide and had accidentally fallen off the balcony. Okay, so mark every single words. Okay, very important. Okay, a lot of people join. Okay, so Daniel and Betty inhabited the penthouse of the luxurious Skyfall condominium with two living mates, Ella and Dolly. Unhappy with the marriage, Daniel began to have an affair with his secretary, Linda. Okay, so Betty's confrontations with Daniel regarding the affair were met with Daniel's denial. So on 13 January 2023, what happened? Around 11:30 p.m., neighbors heard loud voices, noise, and a lady's scream originating from the penthouse, culminating in a resounding thud, which was Betty's fatal fall from the penthouse balcony. Okay. So at this moment of time, you realize that Betty died already. Okay. So Daniel explained to the authorities that he had granted the maids the evening off for him to share a romantic dinner with Betty to rekindle their fading affection. The maids corroborated Daniel's account, but emphasized that their isolation in separate wings of the penthouse, wearing headphones, had rendered them. Wait, got people join. Okay, had rendered them uh, all oblivious to the unfolding turmoil. So Ella praised Betty as a benevolent employer, but Dolly recounted incidents of hostility after being accused of theft of Betty's missing diamond ring, along with threats of termination. So Daniel further stated that he had admitted the affair to Betty, but had promised to terminate it. Daniel claimed that Betty flew into a rage, hurled a chair at him, and retreated inebriated to her bedroom. Daniel then withdrew to another room, where he was later jarred by a scream followed by a chilling thud. The postmortem of Betty revealed that the marks on her body are consistent with the possibility of her being pushed over the balcony. Betty's friend, Jane, disclosed to the authorities that Betty had informed her that she was going to ask Daniel for a divorce and was prepared to face Daniel's wrath. In the course of investigation, it was discovered that Daniel's sister, Delilah, had fallen to her death from 40th floor of Daniel's parents' condominium after an argument with Daniel. Okay, seems like a long facts here and a lot of critical points that you need to take notes of. So your approach is how during examination. First, you must look at the question first, then you go back to the facts of this case so that you can save your precious time. Okay, very important, eh? So, in this particular question, you're asked to discuss about, you see, if it is question A, B, C, and probably inclusive of D, isn't it? Okay, they ask you to zoom in to the chapter of relevancy, whether the facts itself is relevant or not. Okay, important, eh? Okay, so your approach, I already said, read the question first, followed by the scenario. And then subsequently, what you need to do is you must determine whether this is a criminal or a civil case because the burden of proof is different. Okay, very important. And what is the fact in issue? In this case, Daniel is charged for murder. First paragraph, first sentence. See or not? Okay, where's my pen? Okay, charged with murder. So it is a case of PP against Daniel for section 302, murder. Okay, very important. And subsequently, you need to zoom in to the topic that they ask. And lastly, you must be crystal clear about the parties involved. That means who are these person? Okay, who the identity of this you see all the names appear here, isn't it? Jane, Delilah, Dolis. Who are them? You must have a clear set of mind. Okay. So first thing first, the first information provided is as such. Daniel and Betty are married and live at Skyfall condominium penthouse. So when you are asked to discuss the relevancy of this fact, what you are going to say, okay, because you are to advise this party, you are advised PP, okay? So you are just imagining that you are a DPP in court, all right? So you have to advise two issues, relevancy plus admissibility of the following facts. Okay. So first answer, okay. First answer, not too hard. Okay. Daniel and Betty are married. Okay. First information, you have to, because whenever you see a word and, so this is a compound sentence. Okay, I hope you do know what is compound sentence. Whenever you see so, because the sentence itself contains two facts. Okay, ada dua fakta penting fakta Okay, so this is first point and this one is second point. So you have to elaborate accordingly in order for you to score 2 marks. So first facts, Daniel and Betty are married. So this is one of the relevant fact under your Section 9 Evidence Act to introduce the victim and also the orang kena tuduh relationship. Okay, very important. And some more, you see the second facts here is time for condominium penthouse. So the incident, the whole incident of murder took place at this condominium. I hope you do agree with me. So both live at Skyfall condominium. Okay. So to suggest there is occasion or opportunity to commit the crime. So this can be admitted under your Section 7 of your Evidence Act 1950. In this sort of short question, do not delve into the discussion of or describe only section, I mean, to describe only facts in issue or relevant facts are admissible, section 5 and etc. No need. You just have to identify the what we call the requirement of the question well, and then answer accordingly. So subsequently, you need to decide whether it is admissible or not. Okay, since this evidence, these two facts here are relevant, therefore, it is admissible under your section 136 of the Evidence Act. Okay. So Daniel's affair with Linda. Okay. So Daniel's affair with Linda. Okay. You must again try to explore, because relevancy chapter itself is a very broad chapter, Okay. The section is ranging from 5 to 55. So all the proviso under your section 5 to 55 will be considered as relevant evidence. Okay, so you can admit one fact, maybe is under murder. That one is very clear cut lah. Okay, Daniel's affair with Linda. Okay, there's no much argument. But somehow or rather, maybe you can also explain because Daniel is having some extramarital relationship. Therefore, the relationship of Betty and Daniels is getting sour. So this is one more leap that you may want to apply to admit these facts, okay? And as usual, you submit that these relevant facts are admissible under section 136. Okay. Dolly's narrative of Betty. Okay. So what Dolly said, okay, you must recall, Dolly is one of the maid, isn't it? According to the question here. Okay. So one maid said that the Ella praised Betty, but subsequently, Dolly seems to not agree. And she said that there is a incidence of hostility. Okay, maybe she herself is being accused of stealing things lah inside the condominium. So Betty throw tantrums to her, I mean throw a temper to her. Okay. So what happened is you must highlight a bit, okay? You see, this is a case back to the point, it's about murder, isn't it? You agree, this is a murder. So murder, when we confine to the relevant facts and also facts in issue, as a DPP, you cannot admit some unrelated matter. So if this Dolly's version of story is to discredit the victim, say that maybe during her life herself is she's not a good person. So it has nothing to do with the facts in issue and relevant facts, okay, under the meaning of section 5 of Evidence Act, because nothing to do with the charge of murder at all. Okay, so therefore you have to dismiss it. Okay, you must say that since this is not a piece of relevant evidence, therefore it is not admissible. Okay, clear cut, must be able to differentiate now. Okay, so next, we turn to examine the loud voices, noises, lady scream, and resounding thud heard by the neighbors. Okay, so you recall a bit lah, what is what we call the neighbors have recollected. Okay, so this is the information that you can copy from the question. On 13 January 2023, around 11:30, neighbors heard loud voices, noises, lady scream originating from the penthouse, okay, culminating in a resounding thud. which was Betty's fatal fall from the penthouse balcony. So you can see there is time. That's why a lot of marks must be able to dissect it. Otherwise, your answer is too short. Very difficult. You just say, oh, this is a relevant facts, therefore admissible. So hmm, there's a there's a lack of analysis on your part as a DPP. Okay, now you have to really behave like a DPP. You must conceptualize everything. So there is a time and place here. So section 9 introduce where the murder took place and possibility of this victim's identity is the lady. You see or not? Corroborative evidence. Corroborative means supportive evidence. Okay, because at the end of the day, you make a case in the court, isn't it, before a judge. So you have to put in like a pieces, of evidence, forming a whole piece of like a puzzle, piece by piece. So every single evidence that has relevancy, you must be able to put in. So the the court will eventually find out the proof or the whole picture of that incident. So this piece of what we call the scream lady, scream means there is a circumstantial or corroborative evidence to suggest that the victim is a lady. Okay, subsequently, you hear a lady screaming and noises. Okay, so section 7. Okay, probably you can also infer or give inference to the judge that the cause of murder could be due to some sort of provocation, or there are some fights ongoing between the victim and accused. So you see, you have to describe why you say section 7. Reasoning is very important. So it is corroborative. Is it corroborated with Daniel admission of the incident that she did quarrel because Betty throw chairs, everything against him, isn't it? So this evidence is there, okay? And resounding type means, okay, the effect, you see or not? It corroborate with your post-mortem report. Remember, just now when we read, okay, post-mortem report suggests that the body, I mean Betty died because of falling from high, isn't it? So therefore, whatever pieces that can connected to this post-mortem report is very important. Otherwise, it may subject to challenge. Okay. Otherwise, your expert, I mean your forensic pathologists that come to the court probably will, okay, is there any other cause that can cause this sort of cause of death? Probably some crush injury on and all that. So your the chain of evidence becomes not so good, not so intact. And then this is some cast a doubt lah to the prosecution case. Eventually it will lead you to disaster. It's a DPP. Okay. So conclusion, these are all circumstances evidence. You see or not? These are all like inference, you do not see the murder directly. I mean the neighbors do not actually hear what we call the whole set of murder is actually took, or we try to propose a suggestion here. Probably Daniel would have pushed Betty down from this Sky 4 condominium, isn't it? But the neighbors did not see it. But these sort of circumstantial evidences are relevant to form an unbroken chain, like I've told you, to make sure the puzzle is being solved one by one. Okay, so all these facts are relevant and admissible. Okay, at this stage is still quite easy. Okay, so next we have to see, usually the easy one, they won't give you too much marks. Okay, the hard one, they'll give you a lot of marks. See, Jan's statement of Betty's intention for divorce. Okay, you see, Betty's intention for divorce. Okay, the source of information is actually from where? From Betty's own mouth, isn't it? You agree, If I say I want to divorce my wife, my friend cannot talk on behalf of me, It can, take, for example, Jen go and testify in the court saying that Betty told me, cannot. This one is not a first-hand information. Please be clear with that. When you have this what we call you must this information, transmission of information, as far as possible, the court will demand first-hand information. They don't want people to pass the message around. Okay, but now Betty is dead. So the maker, okay, of the statement is that now the whole statement here, okay, cannot be verified. Isn't so? Because the maker passed away. Okay, render these statements to be a form of hearsay evidence. Be very clear at this moment. Okay, hearsay in Bahasa Melayu means kabar angin. That means rumors. Okay, so hearsay evidence as a general rule, it is not admissible. Okay, R against Subramaniam, classical case, okay, as the maker was not present in court to give testimony. So the veracity or the accuracy of the statement is jeopardized with doubts and unreliability. Very, very important because one can pass message around to another one, okay, and then to one more person, and after that, the whole the whole version of the story can be twisted and changed throughout this process of transmission of information. Okay, since we say this is hearsay, by right, this evidence cannot be admitted. However, there are exceptions to hearsay rule because eventually, why we have this sort of hearsay rule? That is to ensure, okay, justice is served. Eventually, there's only one thing the court is doing, keadilan, okay, justice. Some people die, some people can't make it to court. Does it mean justice cannot prevail? It is not the case here. So in this regard, you have to see the best fitted proviso that you have learned so far will be probably dying declaration, isn't it? The section uh, 32 sub-rule 1 sub-rule A. Okay. So in this regard, you as a DPP, you must know section 32 sub-rule 1 is the whole ABCD lah, is hearsay exception proviso. But because the court generally do not accept hearsay. Saya tak mau dengar kabar angin. So there are certain criteria. The strict criteria must be adhered to. Okay. So as a DPP, you will need to, of course, tender death certificate of Betty to discharge the burden that the maker is dead. Okay, very important. So this is pursuant to your burden of proof chapter. This is section 104 of your Evidence Act. Okay, step by step, you argue your answer to make it sounds like you are ready to be a practitioner already. Okay, so section 32 sub rule 1 sub rule A, or generally known as dying declaration, but this is also subject to a lot of arguments with this term. Okay, so we just use here section 32 sub rule 1 sub rule A. Concerns about the dying declaration of the maker, they are strict criteria to be adhered to. For instance, okay, so what are those criteria? The maker is dead. Okay, so in this case, it is satisfied lah. I mean, one part, okay. Okay, Betty is dead. The case is one in which the cause of the maker's death come into question. You see, now, is it the intention of divorce can easily cause a person death? If let's say today I declare, okay, I'm going to divorce my wife. So does it mean that I have a chance to get killed by my wife? Of course, there's a possibility, but that is too remote, isn't it? I mean, people divorce every day. So you must argue, in this event, Betty's intention for divorce is not related to the cause of her death. Okay. Furthermore, the C statement was not made as the cause of her death or circumstances of the transaction resulting to her death. Okay, what does it mean by this criteria is that, okay, for example, I told my wife that I'm going to go out to meet um, Mr. Michael, but subsequently I was found dead. So Michael was charged. So the statement that I told my wife that I am going out to see Mr. Michael now is becoming my dying declaration because it forms a transaction that probably I go out with Michael, Michael kill me, then die like that. So you see, now Betty's told Jan, yeah, I want to divorce what we call with Daniel. Now, is it I mean, is it a transaction? Is it like step one, step two, step three, step four? Clearly, the remoteness of this statement got problem. Okay, after so many days, for example, you see the case of Yo Hock Chang. Okay, statement made 9 days ago. So far, I mean, it's not like today you say you go out with Michael, then you die after that. Yeah, probably we can say that this is a circumstance of the transaction, but this is clearly not our argument in this case. Lah. Okay, last but not least, the exact words of the deceased shall be used without alteration by the witness. So these are the criteria, all of it must be fulfilled in order for you to admit this sort of statement under section 32 subrule 1 subrule A. So if not, you as a DPP, you'll be subject to a lot of scrutinization during the process. So considering all the above factors, you can say that the criteria of section 32 subrule 1 subrule A are not fulfilled. It is likely that Jan's statement of Betty's intention is not admissible. So you already explained. So use one case here, Yo Hock Chang. Okay? Yo Hock Chang. So far, so good, Hmm. Okay, the incident regarding to Dalila. So, okay, 7 marks. That's why I say the difficult question, they give you a lot of marks. Okay. So the incident regarding to Dalila is what? So you have to zoom in. What is this? So apparently from the facts itself, as you can recall, Dalila was Daniel's sister. So after one fighting incident with Daniel, Dalila fell down from the condominium, I think about 37th floor, parents' condominium. So this is one of the similar fact evidence. Okay, let the examiner know very fast that you know what they are asking you. Okay, so again, you said that general rule, similar facts evidence not admissible. Okay, the evidence of any act or conduct not covered by the charge of the accused is being trial is inadmissible. What does it mean? PP, Lawan, Daniel. Okay, the charge is going to frame that section 302. Okay, so confirm is a what we call murder already. So the charge here must have actus reus and mens rea. Okay. For this instance, okay, the charge itself is not regarding to the death of Delilah, isn't it? So therefore, it is generally by virtue of general rules regarding to SFE lah, the similar facts evidence, anything that is not related to the death of Betty in our question cannot be admitted by court. Okay, I hope you are very clear with what I'm saying, and you can refer to Makin against Attorney General. It is held that the evidence for the purpose to show an accused has general criminal disposition is not admissible. Okay, that means to say you are trying the matter, not trying the he's a habitual offender. I mean, he's having bad character, having similar facts, incidents in the past that suggests that he is more likely to be the murderer. Okay? He's more likely to be the killer. So he can be charged. Not like that, Okay. So there are statutory section plus common law exception. Okay, at this moment of time, at least you have some background. Okay, Malaysia, we have exception for SFE. Okay, these are your section 11 subrule B, section 14, and section 15. These are your statutory exception. Okay, and then you have your common law section. Common law is governed by one landmark case like Bodman lah. Okay, so Daniel here is charged, like I said to you, section 302 penal code. So in this instance, okay, if you want to admit this piece of evidence as a DPP, okay, you can only use it for the purpose to prove the state of mind. What is this killer? What is Daniel thinking at the material time? Not to prove the act, but to prove the intrinsic, what the intrinsic thinking. Okay, what is his intention, etc. Okay, so you have your section 14, okay, which provides for the relevancy of facts showing the existence of a person's state of mind, particularly the intention in the murder charge against Daniel. Okay, be very sharp in your words, lah. Okay, in this manner, the incident regarding to Delilah could show that Daniel probably, okay, had some sort of premeditation or forethought, as he would have probably did the same towards Delilah in the tragic incident. Okay, this is trying to say that, okay, you see, they when they push somebody down from the uh Skyfall condominium, very high, isn't it? So sometimes they can raise a defense of I'm not intentionally, I do not have knowledge. If I push him, he will sleep, and then Betty will die. So they'll uh raise some sort of defense. But having the similar experience in the past, he might have, oh, if I push Betty down from condominium, she would have died just like the way Delilah did. Okay, so this is how you argue. Okay, and section 15 is relevant where there is a question whether the act was accidental, intentional, or done. Okay, if you look at the facts given, you see, we go back to facts, Daniel argue to DPP, this is accident, see or not? Okay, accident. Once they raise this sort of defense, then section 15 can set in to rebut. Okay, where is it? Okay, section 15 can use to rebut such defense of accident. So But of course, during examination, I can tell you frankly, even I, as a practitioner, I have to spend one day, going through the question, digest it very sharply, for the purpose of teaching. So during examination, you have basically about 30 to 45 minutes per question. Sometime you may, that's why practice is very important. No? You may miss this sort of facts given in the long question. So, but back to our discussion, Daniel is likely to raise a defense of no knowledge or intention to kill and ultimately causing her death. Okay, so section 15 is used to rebut accident, mistake, or innocent intent. So again, section 15 is not to prove the act, but state of mind of Daniel. Okay. So you say that this is relevant already. I want to rebut his defense of accident. Okay. And section 11 subrule B, Evidence Act. Okay. In PP against Ang An An. So Raja Azlan Shah, okay, the Chief Justice time, seems to suggest that if the identity of the accused may be shown by these similar facts evidence. 11B, okay, seems to be a broader proviso, Of course, you have your argument, the Junaidi and Azahan about, before the enactment and all that, okay. But this is not very important. You have to be a bit quick, okay, because you still have a lot of points to argue. Don't drag yourself too much on the what we call the law argument basis unnecessarily. Okay, so common law exception, Botman, following Junaidi, the court determined that common law exception as a separate ground to admit similar facts evidence. Because as you all know by now, okay, common law can only accept by court when there is lacuna in Malaysia law. That means Malaysia law do not provide any laws or any legal standing towards a certain area, then you can admit common law. But somehow or other, Junaidi here said that the court accept common law exception as a separate, despite of you have already statute 14, 15, 11B to provide room for similar facts evidence. Okay, so in the case of Botman, the test divided into two parts. Number one is similarity. Okay, similarity here you need to play a bit with words. Okay, this does not need to be strikingly similar, but as long as they are similar enough, that means no need to be 99% same, but somehow or other 80% lebih kurang sama, then the court can say this is a similar fact. Okay, you get what I mean? Then the second part is probative value of this piece of evidence must outweigh its prejudicial effect. Every evidence itself, okay, because this is itu penimbang okay, like this, okay. There's a two round plate here. Okay. One evidence you put here, you put. So every single evidence will have weight. Berat. Okay, weight. So automatically the scale will tilt, isn't it? Okay, towards PP if the evidence are heavier than the other side. So that is to say, every single evidence will have prejudicial effect to the parties involved. Okay, so what it means here is that the weight itself, okay, must be big enough for the court to be convinced to take this evidence. Okay, so taking into account of the factual circumstances, you must again be critical and analytical. So the incident regarding to Dalila is what that you can because you are in the position to charge Daniel, isn't it? You as a DPP. So you must submit in this way to be in favor of you. So you must submit that this is a very similar death. Lah. I mean, both victims die after argument with Daniel. It can't facts, to argue similar facts evidence, not to salin bulat whatever the law itself, they don't want that, leh. Okay, so they both die after falling from a sky-high condominium. See or not? So similarity is there. And it is able to show the intentional mind of Daniel, section 14, and rebut the accident, okay, section 15, to suggest identity of Daniel. Okay, you see why I said so? You see, only 4% were in the penthouse during material time. The two maids, Ella, Dolly, victim, Betty, and also Daniel. Who else could it be? So you can probably use it. Okay, Ella, Dolly, tak ada similar fact evidence. Okay, so the higher probable person that might push Betty down is Daniel. But obviously, this is subject to challenge lah. Okay, but if I am the DPP, I will submit in this way. So I will say that the probative value of this evidence is more than its prejudicial effect. It is likely that similar facts evidence shall be admitted by court. Okay, as simple as that. Okay, so far so good, Can understand, Okay, I hope you are still with me. Hmm. Okay, we go to the second question. As the presiding judge in the case, explain by reference to Evidence Act 1950 and relevant case laws how you would consider the following evidence. Okay. The admissibility of Sergeant Brani's affidavit. I think this year punya question quite tough, a lot of opinion, competency, compatibility issues. Okay, so we first read the question, what is it first lah? Okay, Billy commenced legal action at KL Session Court against Pseudo for negligence. So this is a civil case, negligence suit. So Billy claims that he sent his car to Pseudo's workshop for general service, that Pseudo had failed to diagnose that the car brakes were defective. Billy claims that soon after the general service, he had an accident with his car and a total write-off. Billy is now seeking inter alia damages, interest, and costs. So at the trial, Pseudo sought to admit in evidence Sergeant Brani's affidavit, okay, which contained Sergeant Brani's opinion that the accident was not caused by the defective brakes, but was caused by Billy's reckless driving. So Sergeant Brani made the affidavit prior to the trial. He's now posted to Sabah and is unable to attend trial. Pseudo's counsel submitted that A. Sergeant Brani was the police officer who investigated the accident. B. Sergeant Brani's leave to travel to Kuala Lumpur for trial has yet to be approved by his superiors. And C. Sergeant Brani had no material interest in the outcome of the present proceedings where he made the affidavit. So Billy, of course, objected to the admissibility of the affidavit on the basis that Sergeant Brani had no personal knowledge of the allegation made in the affidavit. It was his opinion, it is hearsay. So it is prejudicial to Billy, and for this reason, the affidavit has to be excluded until Sergeant Brani has been cross-examined on it. Billy's counsel, on the other hand, sought to adduce through Billy's statement, detailing all the loss and damage suffered by Billy arising from Pseudo's alleged negligence. The statement was prepared by Susan, Billy's wife, who was not called as witness. Pseudo's counsel to the statement to be tendered through Billy's on the ground that Billy was not the maker. Billy's counsel replied that Susan, being Billy's spouse, is not competent and is not compellable to give evidence in reliance on Section 122 of your Evidence Act. So Pseudo also object to Billy's intention to adduce WhatsApp communication with Austin, the manager of the car manufacturer, claiming that the defects in the brakes could be easily detectable and use reasonable skill and care. So as the presiding judge, you see again, your role here is very clear. As the presiding judge in the case, explain by reference to Evidence Act 1950 and relevant case law how you would consider the following evidence. Okay, this question quite tough, frankly. Okay, first, the admissibility of Sergeant's Brani affidavit. Okay, first and foremost, see, 12 mark automatically, okay, whatever that will come into your mind now, it cannot be just one issue, okay? It must be having a lot of challengeable issues, okay? So brief facts is that you must say that this is a civil suit between Billy and Pseudo, in which plaintiff is claiming damage from defendant for failure to diagnose the car brakes to be defective due to negligence. Okay, if you read case law, this is how the presiding judge would have drafted their statement. Latar belakang, okay, background of the facts a little bit first. So you jump to the question. Sergeant's Brani opinion evidence. Because from the facts, you know, right? Sergeant Brani, IO of the case, give opinion as to the cause of the accident was actually attributed, okay, to plaintiff reckless driving instead of the defective brake. So this is laying down the purpose of this evidence. Everything, every what we call evidence that you tender must serve a purpose, you know. Like I told you earlier, to solve a certain part of puzzle, you don't simply admit evidence for no purpose or for no reason. You are wasting the court time. Okay, it comes to the light that Sergeant Brani is not a factual witness. Okay, as he did not perceive the accident with his own five senses. Okay, so now you know, okay, refer to Section 3 Evidence Act. What does it mean by fakta, facts? Okay, that means you must see it, you must hear it, you must smell it, you must listen to it, or you must feel it. That is your five perceptive senses. Human punya, okay? Lima deria utama. Okay. Instead, it is an opinion, evidence as submitted by the defendant's counsel. Okay, not the court say, the defendant's counsel said so. The opinion is based on his inference or belief based on the factual circumstances. Here you can use one case here, Wu Hee Chiang against PP, a drug case. Okay, so the court take note that the evidence is generally not admissible because now you have to write your answer on your position as the presiding judge. That means you are the session court judge now. Okay, unless it could assist the court in specific area, for example, science, arts, handwriting, foreign law, and fingerprint, etc. Okay, considering Brani is an investigating officer, okay, of this case, he does not have expertise to determine the cause of evidence and assist the court in the area of road traffic evidence. Okay, now it is very important for you to frame because your judgment eventually you can only seek to admit this evidence or you want to reject this evidence. Okay, I am in the position to reject this evidence, That's why I draft my answer all in favor of this part. Why I reject, okay? So therefore, I said that he's not even an expert lah. Okay, therefore, he could not be categorized as expert witness under the meaning of Section 45 of Evidence Act. The procedural rule for expert opinion was actually provided under your Order 40A of your rules of court because civil case ma. Okay, the defendant's counsel submitted that Brani has no conflict of interest. Okay, very important why I argue here because as a presiding judge, okay, your role is to hear plaintiff and defendant counsel submission. Apa hujahan daripada plaintiff? Apakah hujahan daripada defendant? Yang manakah hujahan awak terima pakai? You understand what I'm saying? You cannot go too outside from what they have submitted. Okay. So I said that even though the defendant's counsel said Brani has no conflict of interest, but yet this issue will not influence the court view that of this expert witness issue. Okay, the court also dismissed. Okay, see or not? Is it necessary for him to help the court to establish the cause of the accident is due to reckless driving or not? Okay, especially since the purpose of the evidence was to establish the cause of the evidence. Because like I told you earlier, you can only admit or reject. My position is very clear. I want to reject in totality lah. That's why my judgment is all about negative things about this affidavit. Okay, so Sergeant Brani's leave yet to be approved. This is another issues raised by the counsel, isn't it? The court posits that an affidavit is a sworn statement made by the deponent. Okay, if you read carefully, affidavit is not actually governed by your Evidence Act 1, Okay, affidavit is on its own, Okay, so you read carefully Section 2 of your Evidence Act. So therefore, the said affidavit could not satisfy the documentary evidence limit pursuant to Section 32, Subrule 1, Subrule B, or Section 73 A of Evidence Act. Otherwise, the counsel, the defendant counsel will seek to admit this affidavit as one of the document. Okay, so by having things that I said this affidavit is entirely different from what you write and sign. This one you sign before a Pusurujaya Sumpah. This is not a normal document. So the plaintiff, the defendant counsel, okay, this one some mistake, okay. Defendant counsel could not seek to admit the said affidavit by dispensing the attendance of the witness. Okay. Next, the court shall judiciously consider the plaintiff's counsel submission. That's why 12 marks, you see. You cannot just end your answer with, I know this is what we call opinion evidence. You cannot just write Section 45 opinion, then habis cerita. You'll get 3 marks. Okay. If you analyze the question and put forward your argument as a fit and proper presiding judge, wow, you score. You score. Okay. So personal knowledge in affidavit. The plaintiff counsel contended that affidavit contains hearsay evidence. Brani was making a statement without personal knowledge. So what's your view on this? The court, because I already want to reject Brani's evidence, I have to agree with the counsel submission, isn't it? I cannot, both parties I not agree, then put my own views. This is not the rule of practice in Malaysia court. Okay, the court will agree with this contention by referring to Tiffany Chow against Jabatan Immigration Malaysia, where the applicant's affidavit in support was made in contravention to Order 41, Rule 5, Sub Rule 1, Rules of Court, which requires an affidavit to contain only such facts as the deponent is able of his own knowledge to prove. Okay? Because inside an affidavit, usually the first two sentences, I don't know whether you see an affidavit before or not. Let me just find one. Usually, first few sentences, it will consist of you have to say that ini dalam pengetahuan saya, you know. You cannot simply say something that you do know, you know. Okay. Okay. Let me just find one affidavit here. Okay, this is one case here. You see, first, if you, let's say, for example, you make one affidavit, you have to introduce yourself. Subsequently, this is very important. This is a standard format. Melainkan dinyatakan sebaliknya, perkara-perkara yang dipostkan di sini adalah benar dalam pengetahuan pribadi saya dan atau pengetahuan yang diperoleh daripada rekod dalam simpanan saya. That is why your affidavit cannot contain some hearsay evidence. You understand, Okay. So you must agree with whatever the what we call the plaintiff counsel said lah. Okay. Opinion in affidavit. In the case of Qasim bin Sulong against Guthrie Estate, the court held that where exhibits to the affidavit state an opinion of law, that opinion of law is not admissible. Okay. It is the function of the court to decide on question of law. Since the affidavit in question comprised of Brani's opinion about the accident, it could not be admitted. Okay, so this is your what we call your standing here. Okay, last you consider another submission by the plaintiff counsel, hearsay issue. Okay, because Brani was not there, he was in Sabah, isn't it? So traditionally, the court would not admit a piece of hearsay evidence as the maker could not be cross-examined to ascertain the truth of this matter in witness box. You can draft whatever sentence you want against Subramaniam, subject to the statutory or common law exceptions. So in this matter, Brani could not come to give oral testimony in court. Use another section, Section 60 of Evidence Act, and the mode of proof had been challenged by the plaintiff counsel because he raised objection already. Okay, you can use Noliana Sulaiman. Okay, take for example, the plaintiff counsel did not challenge the mode of proof in civil case, then problematic. It will be deemed the maker don't come also never mind. Okay, so civil proof, civil mode is, the mode of proof in civil is less, high as compared to criminal. Okay, so relying on the aforesaid reasoning, the court leaned towards plaintiff counsel argument. In conclusion, the court exercised its discretion pursuant section 136 in order not to admit Borani's affidavit. Okay, can understand so far? Okay, because it's quite tricky, you know. So second question, they ask you whether Billy's argument that Susan is not a competent and is not compellable to give evidence is sustainable or not. 8 marks. Slightly easier lah. Okay. So you see here, there are two parts of the question. First is about the whether Susan is a competent witness or not. The second question, you are required to discuss whether Susan is compellable to come to court and give evidence orally or not. Is she a protect witness? Okay, or a privileged witness? Okay. In this matter, you have to consider one by one. Do not jumble up your answer. Okay. The Evidence Act sets a very you are the judge now. Okay. So set a low threshold to satisfy for a person to be competent to testify. So long the person is able to understand the question asked, able to give a rational answer, the court will accept the testimony. Okay, so a very good beginning or introduction to show that actually everyone can give uh, testimony in the court. There's no selective criteria. There's no quota. Okay, there's no certain uh, what we call threshold for you to fulfill in order for you to be a qualified or competent witness. So this is pursuant to your section 118 of Evidence Act. Okay, so all persons shall be competent to testify unless they are prevented from understanding the question put to them or giving rational answers to those questions by, okay, these are the exceptions, okay, tender year. Number two, extreme old age. Number three, disease. Number four, whether of body or mind or any cause of the same kind. That means some insanity lah, unsoundness of mind, okay, or physical unfitness, paralyzed person, bedridden, cannot come and all that, then they are not competent because they cannot understand the question because they suffer from stroke or those cerebral palsy, for example. Okay. Mm. So this is first ground. And you must understand who is Susan in this question. Okay. So Susan is the wife, isn't it? The wife of the Billy, isn't it? The plaintiff in the suit. So you must further elaborate section 120, provided that husband and wife of any party in civil or criminal proceedings shall be a competent witness. So you settle the issue on competency. So at this point, you as a presiding judge must say that the court safely concluded that Susan is a competent witness in this civil suit. Okay, settle one issue. Okay. So second issue here, compellability. Factually, you see, you must go back to the discussion. Factually, Susan, being the spouse of Billy, plaintiff in this suit, is the maker of documentary statement detailing the loss and damage. Okay. Susan was not called as a witness due to the privilege issue under Section 122 Evidence Act as submitted by plaintiff counsel. So Section 122, what is it? It is a specific provision for privilege of communication during marriage. Okay. So the purpose, privilege section, the legal communication privilege, all this privilege is to protect the society one. You must eventually understand one point, that is family is the nucleus of the whole country. The harmony must be preserved between husband and wife. If let's say you do not have this sort of privilege, who you can tell your secret to? This is the intention of parliament to enact this. You must be able to tell some sort of secret to your lawyer. Okay, take for example, to your wife, isn't it? So you cannot just like, what? I tell the secret, then tomorrow then the evidence is incriminating me against me, then I will have this sort of mental problems lah, and I will fight with my wife lah. I mean, the harmony of the family will be jeopardized. So memorize this, and then it will help you to memorize your law. Know the intention behind the law, because law under utilitarianism is to use one. You are not for decorative purpose, isn't it? You want to apply the law into the operation of society. So no person who is or has been married shall be compelled to disclose any communication made to him during marriage by any person to whom he is or had been married. Okay, that's why I tell you lah, the secret you can tell your wife safely, provided you register with her. Nor shall he be permitted to disclose any communication unless the person who made it or his representative in interest consent. Okay, this is keywords, consents, except in the suit between married person or proceeding in which one married person is prosecuted for any crime committed against each other. Okay, take for example, marital uh, proceeding, I mean divorce proceeding. Yes, you can use the secret of each other to attack. They want the relationship, because the law will not operate on a sour relationship. Okay, you remember what I said? The law is for harmonization. Since sudah gaduh, mau cerai, apalah, this is not covered under this section 1 to 2. Or there's a jenayah keluarga, domestic violence. uh, uh, the husband hit the wife. That one can. Okay, whatever they said during the marriage, you can admit to the court. Okay, this is how this operation. So for section 1 to 2 to apply, two criteria must be met. So you have to relate factually, not to regurgitate the law, but to relate the law with this question. Number one, it is well agreed that Susan, who is the maker, Billy is the recipient of the communication, are married. Okay. And the communication was made during marriage. So two criteria fulfilled. Susan, who received the communication, cannot be compelled to disclose. This is first limb lah, because there's a semi comma. You know how to differentiate, isn't it? The first limb and second limb. Okay. Until this black color one, and this semicolon, okay, all this is considered first limb of the section 122. The blue color here is the second limb. Okay, so you see, first limb cannot at all. Okay, and no, she is permitted, this is second limb already, to disclose any communication made to her by her spouse during marriage unless the spouse made it or representative in person consents. So Gos Haji Kadir Mustad. So as a judge, you must be very smart, isn't it? So you must carefully scrutinize the provision, because just now you said Susan is competent already. Now you want to overturn this competent. You want to how you want to adjust your answer. If I will adjust to say that Susan must come to court. You see how I put it this way? Susan shall be called to give evidence based on the details of the loss and damage. Okay, you must understand this is a civil suit. Billy is the one that suffer loss and sue pseudo, isn't it? So Susan will be giving testimony in favor of Billy, for the benefits of Billy one. So there is an implied consent on part of Billy to authorize the revelation of communication information. They must have discussed lah. They must have consent lah. That's why they put in the paper and tender to the court. Okay, so the court shall rule that even Susan is privileged witness pursuant to section 1 to 2, she will have obtained consent from Billy. Just now we said the criteria fulfilled. Now we want to overthrow. How we want to overthrow is by looking at the consent, the consent, okay? So I will say that she consented lah, by Billy. So this is especially true when her evidence is going to be in favor of Billy. So in reaching a conclusion, the court could not agree because at the end of the day, it's only you agree with Billy's argument or not. You cannot stay in between. You cannot say like, oh, Susan, I think, yeah, competent, but she's not compatible. So half half, problematic, man. So the court shall decide as such. Susan is a competent witness, and Susan is compelled to answer all questions in court lah. And Susan is required to come to court to give testimony. Otherwise, the statement of damage will be a documentary hearsay. Okay? Can understand what I'm telling you so far? Oh, am I too, I mean, too confusing? Are you all still with me? Can understand or not? Because I think quite tough, Can Okay. Okay. So next we have to examine the relevancy of this WhatsApp message with Austin. Okay, Austin. So this only 5 marks because it's slightly easier. So first thing, again, you have to consider what is the purpose of this WhatsApp message. What is it for? Okay, the WhatsApp message shall be used to determine pseudo had actually fallen short of his standard of care. Eventually, you know, isn't it? This is a negligence suit. Okay, negligence we have a few elements, duty of care, breach, causation, damage. So this is one of the thing here. Standard of care had been fallen short. That means not up to par lah. Your standard not up to par lah. That's why you breach your duty of care. This is one of the element of your negligence suit. Therefore, it is relevant. Section 5 Evidence Act. So this one satisfied. Okay. Subsequently, you have to examine the admissibility of this WhatsApp message. So in case of Mo Yi Check against Sovo Sendirian Berhad, the High Court held that printouts of email and WhatsApp message fall within the wide meaning of document under Evidence Act. As such, these printout can be treated as any other printed document as to regards of its admissibility. So WhatsApp, okay, there's a one case law said that can admit. Okay. Secondly, you have to examine what form of document is it? This is electronic documents, isn't it? Okay. If electronic documents do not divert your attention too much, okay, you can say that this is a computer generated document pursuant to Section 90A Evidence Act. Okay. To admit under this proviso, the phone owner shall be called to testify in court, or a certificate should be tendered as evidence. Okay, PP against Nana Segaran. Okay, and Section 90A here is a hearsay exception, as Section 90C evidence provide that Section 90A and 90B shall prevail over any other law, It's not any other written law, but any other law, Okay, that means to say Section 90A, but however is it, if it is satisfied, any evidence that prohibited by any laws shall be admitted. So Section 90A, okay. So as to regard to the weight, you have to put in Section 90B, okay, the probative value. So your conclusion, 5 marks question, the court shall admit this WhatsApp message. However, the court must exercise its precaution as to the snapshot of their discussion contain the necessary information to identify the sender or recipient of the message. Okay, this is to show that you understand extra law about WhatsApp. Okay, you must identify whether it's really from Austin or not, and also the whoever the parties involved lah. Okay, and this WhatsApp message, you cannot form conclusive proof. Okay, that means to say now this is to prove standard of care is short, isn't it? This WhatsApp message you cannot be the sole evidence. There must be some other relevant evidence to prove the facts in issue. This is your standing lah at the end of the day. Okay. Okay, question 3. Okay. Harold met Maggie on a dating website named Find Her in March 2017 and immediately embarked on a sexual relationship. In January 2018, Maggie discovered from her gynecologist, Dr. Obi, that she had contracted herpes. Maggie was upset and coaxed Harold to marry her, claiming that he should do the right thing. After she discovered that she was pregnant, Maggie became more persistent with Harold to marry her. Harold agreed, and in May 2018, Harold and Maggie got married. In November 2018, their daughter, Lillian, was born. Harold's job kept him in the office for long hours and increasingly spent more time with his colleague, Chelsea. Okay, so Maggie was upset with Harold's friendship with Chelsea and pressured him to end the relationship. This led to a vicious fight, resulting in Harold leaving the house in January 2023. Lillian witnessed the fight. Maggie then lodged a police report alleging that Harold had abused her. Okay. In May 2023, Harold petitioned for divorce and Maggie cross-petitioned. Maggie wished to raise the issues of abuse, adultery, and also this apa nama? Harold infected her with herpes. As evidence, Maggie wants to produce the following. Number one, Lillian's testimony. Number two, Dr. Obi's report to establish herpes, although Maggie had decided not to call Dr. Obi. Okay, so photograph that Maggie had taken of Harold and Chelsea having dinner on different occasions, holding hands, feeding each other with olives. Harold, on the other hand, denied the abuse and adultery and also denied infecting Maggie with herpes. So Harold wished to raise that Lillian is not his daughter. So with reference to Evidence Act and relevant case law, discuss the following. Okay. So first point, whether Lillian can testify at trial or not. Okay. So on the facts, how old is Lillian now? The facts already give you here. That's why sometimes not easy because you have to read between the line. So exam time, November 2023. So it's about 5 years old. So you can infer these facts here. Okay. So on the fact, Lillian is 5 years old at the material time, and straight away you submit. She's a child witness. If you are good, you can set less than 18 years old based on section 2 of age, what we call age of majority act. Okay, so the purpose of calling Lillian in this matrimony proceeding is to prove the fight. Again, always identify why she need to be called. Okay, who is she? Why she need to come to court? That is to put the prove the fight, isn't it? Because Maggie contended Harold to abuse her domestically. So, child witness, first thing, competency issue. Remember what we have told you? One of the criteria here is that witness cannot understand the question or cannot give rational answer is due to tender year. But the statute, the Evidence Act itself, did not provide clear definition for tender year. Okay, correct? Huh? So long Lillian is able to understand the question and give rational answer, Lillian should be a competent witness. Okay, this is the first issue here. And subsequently, you look at one more part of the child witness. Child witness, we are scared what, We are scared that, yeah, they can come to court, but sometimes, what if they offer the wrong information to the court? So how is the reliability of the child to give witness in the court? Okay, so you must have a preliminary test. So Chow Chong against PP here, children find it difficult to distinguish between the result of observation and their own imagination. Okay, so that's why child witness is classified as interested witness, special witness. Okay, like your accomplice, okay, all that, So they themselves are not very neutral, I would say. Okay, so corroboration will be required. Okay, corroboration means the court cannot be absolutely believe the fight happened with mere evidence of this what we call Lillian's testimony alone. There must have other corroborative evidence, supportive evidence. For example, now in our case here will be police report, then subsequently followed by police report will be a medical report showing that itu apa Maggie was punched or got bruises here and there, abrasion. Okay, that is corroborative evidence. Okay, should Lillian is competent to give evidence, the next question will be whether she should give sworn or unsworn evidence. Okay, so the court will in practice conduct preliminary examination. Okay, of the child witness to determine if Lillian could give sworn evidence or unsworn evidence. This is like the judge will usually ask lah, apa nama kamu, sekolah di mana, umur berapa, ada kawan baik tak di sekolah. These are the question to test, This um, children is able to guide the court or will mislead the court, something like that. Okay. And then the judge will record lah, okay, on and decide whether the child witness can understand the solemn duty speaking the truth or not. Okay, this is under CDEC bin Ludan here. Okay, why is this important? Because after, under an oath, the evidence will carry more weight. Okay, more weight. The probative value of this child evidence become more if she can give sworn evidence. Okay. So if she can understand the nature of the oath, that means her duty to speak the truth, she may be allowed to give sworn evidence. So against in Chow Chong, if Chow gives sworn evidence, a corroborative warning is a matter of practice. Okay. That means to say the court is not by law, but in their usual norms of practice, they must support this evidence with, like I said, the police report, medical report, etc. Okay, to show that, oh, there is indeed a fight. Okay. If it is not sworn evidence, she may be asked to give evidence if she possesses sufficient intelligence to justify the reception of evidence and understand the duty of speaking the truth. Okay, looks same, but the weight, berat, timbang berat, sama. The weight is different. Okay, so in conclusion, Lillian is a competent witness. Should she satisfy the preliminary test of the court, she could testify in court subject to the aforesaid discussion. Okay, eventually you need to answer this question. But the facts of this question only tells you Lillian's 5 years old. It does not disclose to you what is her intellectual level, isn't it? So you cannot simply jump to a rich, oh, okay lah, he can testify lah, no problem. So this is subject to the condition as you have discussed to make a safe answer lah. So second thing is admissibility of OB's report. Okay, again, you have to determine the nature of this proceeding. Okay, matrimonial case, this divorce petition involve Harold and Maggie. So OB, what he want to say in the court, I mean, what his value of this evidence is to prove herpes, isn't it? Herpes, for your information, is a form of sexually transmitted disease. So Maggie purposely wanted to make Harold looks like having a lot of sex around lah. Okay, something like that. Okay, so OB's report will be expert opinion under Section 45 Evidence Act, in which the said evidence had assisted the court in the area of science pertaining to the diagnosis of herpes. Okay, so can agree so far? So Dr. OB should be required to state the grounds on how he arrived on such conclusion. So Section 51 Evidence Act, Chandrasekaran. Okay. Nevertheless, you see, OB is absent to give oral testimony according to Section 60 Evidence Act will render the whole report to be caught by hearsay rule because OB did not come to court. The opposing party, I mean, Harold's counsel, lawyer, has no opportunity to cross-examine OBs at all. Okay, so this will be caught by hearsay rule, R against Subramaniam. And the procedural rule, as I've told you already, Order 48. It is tried law that the maker of the document should come to court to give evidence to prove the content of the documents, unless the documents have been classified in bundle A or bundle B by both parties. So this is civil proceeding anyhow. So if you group it in A or B, that means maker attendance is dispensed. So you don't classify expert in B lah. You classify them in bundle C. In furtherance, Section 53 and 54 of Law Reform Marriage and Divorce Act provide 4 grounds of divorce because it is single petition. Okay, so you cannot say what we call herpes is one of the ground for divorce. It could be only adultery and unreasonable tingkah laku luar biasa, That means hit him lah, can lah, that one can. And always isolate him, that one can lah, deserted or separation for 2 years, that one can. But not this case, Okay, where's my pen? So judging the fact that herpes infection, you see, happened back in 2018 before the marriage, it is worth noting that the incident itself is not relevant at all under Section 5 Evidence Act. So on the basis of the aforesaid reasoning, okay, so Dr. OB's report could not be admitted in the court. Okay, Section 136. I purposely draft my answer in such a way so that because 7 marks, if you say this only, actually you can dismiss this obvious report. But how you want to say opinion later? So practice. So first touch the lighter issue, and then subsequently come to a conclusive one. Okay. So conclusion is the same. Boleh diterima masuk. So second thing is about the photograph taken of Harold and Chelsea. First thing first, examine relevancy. Maggie petition for divorce, okay, under section 54, okay, and the respondent Harold had committed adultery, okay. See, this is the purpose, and the practitioner finds intolerable to live with the respondent. It's one of the facts and circumstances. Okay, this one. You see the photograph taken of Harold for what? For what? Okay, showing them having dinner, holding hands, feeding each other. Correct or not? This is the content of the photograph. Does it ever show adultery? Adultery, by the meaning of a dictionary, is having sexual intercourse between the parties. So the proof itself must be some sort of video, okay, or photograph having sexual intercourse. Okay, but nevertheless, okay, even though this is not a picture that show okay sex is taking place, but still the photograph will be useful as a circumstantial evidence to establish the intimacy of Harold and Chelsea relationship. Okay, so this is under your apa nama? YAY against WHO Malaysia case. Okay, therefore, the photograph itself will be relevant okay, under your Section 5 of Evidence Act. Okay, and pertaining to the evidence admissibility, you see, photograph are a form of computer generated documents. Section 98. Anyhow, it's print out from your smartphone or digital camera, isn't it, nowadays? So the photography shall be required to, it's the same argument just now, 90A to come or give what we call tender certificate, and it is a hearsay exception. Okay. If the mode or the criteria of Section 90 A is satisfied, then the court will need to admit this evidence, Okay. At the end of the day, okay, the photograph will be given probative value based on judicial appreciation. Okay. In conclusion, you must say that photograph taken of Harold and Chelsea are admissible. Okay. Don't hang your answer in between. If you say no, why you say no? You say it is not having sexual intercourse. Then you said so. Never mind one. As long as you give a clear standing. Okay. So the burden okay, of proof that Harold relating to his assertion that he's not Lillian's father. Okay. So 5 marks. This is quite easy lah, this one. So this is a question about presumption of legitimacy, So from the question itself, they give you time frame, isn't it? Okay, they give you time when they know each other, then when, I mean, both Harold and Maggie got married in, isn't it? So this is under your section 112 of Evidence Act, which is a rebuttable presumption of law. Presumption means what? Presumption. Presumption in Malay called anggapan, Anggapan. Anggapan, that means you just need to show brief facts. Okay. Commonly, presumption of law in practice are those presumption of knowledge, presumption of trafficking in section 39B DDA case, drug trafficking. If you have a lot of drugs, for example, more than personal consumption. Take for example, I have 1,000 pieces of these pills of ecstasy pills. I cannot tell the court the facts are 1,000 pills, okay, all drugs. I cannot tell the court, wait, I'm not trafficking. Actually, I want to eat it myself for personal consumption, Cannot. Because basic facts are there, are being established. Okay, same thing here. If you look at your section 112 Evidence Act, the brief facts need to be established is number one, there is valid marriage. So on the fact, both Harold and Maggie were married. Okay, and the timing of birth, Lillian was born during the marriage between them. Since the basic facts were established, the presumption of law pursuant to Section 112 Evidence Act shall automatically set in. As simple as that. Okay, so Section 4 Subrule 3 of Evidence Act further indicates that presumption, okay, this anggapan thing, okay, once established, is conclusive proof of legitimacy. That means to say, Lillian, who had been what we call had been born during the marriage between Harold and Maggie, and the timing of Lillian was born is during that particular marriage. So confirm Lillian is the legitimate child of Harold and Mary and Maggie. As simple as that. Okay. So by operation of law, Harold shall be Lillian's father. Okay. However, okay, because 5 marks, 5 marks cannot just stop like that. Okay, you cannot go and discuss DNA, all that. That means that is signifying that you are watching a lot of movies. This is not the operation of law. Okay, so however, looking closer at the wordings of Section 112 Evidence Act, Harold shall bear the burden of proof. See, okay, because eventually the burden of proof, isn't it? Okay, Section 101, Section 102 to rebut this presumption. Okay, so how he want to rebut is only by one solid reason that is pursuant to your Section 112. Okay, he, Herod, must prove that the parties to the marriage had no access to each other at any time when he could have been begotten in order to rebut this presumption. Okay, it's not by way of DNA, blood test, whatever. No, they have no access to each other. Okay, this is the only way that apa nama Herod can rebut the assertion. Okay, so quite simple. You see, this is I make things easier for you. The clear wording of Section 112. Okay, finally, we come to the last question. A bit delay of time. I hope you guys don't mind. This sort of question, isn't it? Like, they specifically talk about one case law and it's your opinion. My personal suggestion is if you never come across with this sort of case law in your life, okay, and you do not have basic or solid knowledge about this sort of case, unless the situation really, I mean, warrant you to do so, better avoid this sort of question because the argument itself is very lengthy one. Okay, but first, we just cover the whatever we can cover in this question. There is a difference between the evidence of a person which is based on his special knowledge and expertise within the meaning of Section 45 of Evidence Act and persons who are not experts but have experience in certain fields. It is the norm that the court relies on expert opinion on certain subjects to help it in arriving at decision of a particular case. However, non-experts are also allowed to give their opinion on certain areas. Non-experts are people that who do not have to be regarded as professional experts by the court in this area. Per Zabaria Federal Court Judge in J. Holmes Seniran Berhad against Sivanathan Krishnan. Okay, so you are required to refer to Evidence Act and relevant case law, explain situation where non-experts are allowed to give opinion for the purpose of assisting the court. Okay, 12 marks. Okay, so my argument, you must, that's why lah, if you do not know about this case law a bit, difficult and a bit challenging for you just to chincai bochai and write down, Okay. So this case law particularly, yesterday I just did a research and this answer freshly back. So it may contain some grammatical errors. Should any one of you detect it, just let me know. I will make the amendment. So what happened is this case law itself mainly discuss section 49. Okay, section 49. Okay. So under Evidence Act, opinions are generally not admissible. Okay, admissible when provided by experts in their field as outlined in section 45. There is a difference between evidence of a person, which is based on his special knowledge and expertise within the meaning of section 45 of evidence, and person who are not experts but has experience in certain field. Okay, it is norm not it is the norm that the court relies on expert opinion on certain subjects to help it in arriving decision of a particular case. However, you see, non-experts are also allowed to give their opinion on certain areas as enumerated under section 49 of Evidence Act. Okay, non-experts are people, this is exactly from the case paragraph. Non-experts are people that who do not have to be regarded as professional experts by the court in this area. These areas are stated under sections 47, 48, 49, and 50. So your essay shall discuss all this. Okay. The discussion revolve around section 46, 7, 8, 9, and 50. Okay. So what is section 40? 7. Opinions as of handwriting. Okay. Handwriting is exclusive in its nature. You can call Jabatan Kimia the expert opinions to show that a handwriting is forged. At the same time, you are also allowed to call somebody who is not an expert, but being a personal secretary or a clerk of an individual who is familiarized with the handwriting of the person to give evidence in the court. Okay, so this is one of the exclusivity. Okay, handwriting can be admitted under section 45 and also section 47. Okay, now we talk about 47 first. Okay, provided they are familiar with the handwriting in question. The key requirement is that the person offering the opinion must have substantial familiarity with the handwriting through personal dealing or correspondence. Okay, one is said to be acquainted with the handwriting if he has seen the person write. Normal circumstances is the spouse, the clerk, the person that co-workers, they have seen the person writing. I know I can charm. I boleh charm dia punya tulisan like that. Okay. Second, when he received documents purporting to be written by the person in answer to documents written by himself or under his authority and addressed to that person, or when in the ordinary course of business documents. Okay, in this case, Lim Kim Luang against Li Xiayi, evidence of a weakness on a person's handwriting was not relevant as there was no evidence to show that he was acquainted. Okay, the keyword here is acquainted. Dia tahulah dan boleh camkan tulisan seseorang individual tersebut. Okay, this is 47. So 48 is about customs and tenets. Okay, this one we hardly apply in my life. I mean, until now we haven't even applied this. Okay, but according to proviso, section 48 permits non-expert to give opinions as to regards to custom and tenets of any body or man or family. Okay, So these opinions are admissible if the person has substantial familiarity. Again, that is the keyword here, lah, must know lah. Okay, with the customs through observation or participation. Okay, in my personal opinion, usually you ask this sort of non-expert witness, he or she must come from those Persatuan, like Persatuan Hokkien, Persatuan Teochew, something like that. Okay, so in Wong Ni Liu against Ng Yun Tai, the court may look at the findings of other courts where the court held that in determining the question of Chinese custom in Malaya in relation to divorce, there must be an intention to divorce and it must not be kept in secret, something like that. Okay. And then section 49. Section 49 was in fact discussed in a lengthy manner by this Jets Home case. Okay, in which section 49 provide relevancy of opinion of person who have special knowledge, special means of knowledge on the matters mentioned in section 49 subrule C must be read together with section 98, which provides that the evidence may be given to show the meaning of unreadable or not commonly understandable characters of foreign, obsolete, technical, local, or provincial expressions. Okay, that means to say one of the example that I've read is, okay, this one, Sim Ah Song case against Regina, okay, is a Judy case. Okay, Judy case, they kept some sort of record, isn't it? 1436. And then they keep four number, isn't it? So who can testify or give opinions as to this sort of record? This is a Judy. Ah, the court in this case held that an experienced police officer from gambling suppression branch, they can do that because they know by experience how the lottery system work, and the court agree with them. Okay, and section 49 subrule C must be read together with section 98, which provides that evidence may be given to show the meaning of intellectual or non-intellectual characters. Okay, again, it's the same lah. Okay, in a peculiar sense. Okay, because anyhow, this number is just a character, isn't it? It doesn't carry the meaning of gambling. So how do you prove? Okay. And one more case here you may want to look at is PP against Lee Yi Tiong. Okay, again, the court was faced with an appeal against a conviction for assisting in carrying on 1,000 character lottery. Okay, so a lot of lottery case lah, because uh, they are quite exclusive. Only they can interpret what they write, isn't it? So the court asked police officer who had experience in dealing with all this lottery to give their opinion. Okay. So section 50, so section 50, we look at it, is his opinion expressed by conduct of the relationship of one person to another is relevant. Okay, such opinion is not a hearsay and it is from the person who has special mean of knowledge of the relationship in question. Frankly speaking, I have not applied any of this opinion evidence in my life before, but there is a illustration given, and in what we call Ong Cheng Neo against Yip Pie Neo for evidence of marriage, where the court held that the evidence of reputation of two persons being husband and wife is evidence of such marriage. Okay, and Tam against Wate, evidence called by plaintiff and their witness on relationship was hearsay and therefore not admissible. But the court somehow allowed section 32 subrule 1 and E and subsection 50 subrule 1 to operate. And it is from persons who had special mean of knowledge of relationship of two persons. So from the aforesaid discussion, you can see the court give 47 till 50, that actually provide rooms for those non-expert to be admitted as witness in the court. Okay, particularly which is critical in cases of technical and special knowledge area, They don't simply call, like custom they call, handwriting they call, etc. Okay, so this is the position here. Okay, one more question to go. Okay, the nature of our system is adversarial. This means the judge has to listen to submission of cases put by each party to an action. The judge role is akin that of a referee. Okay, so however, although the adversarial system requires the judge to act as a referee to the dispute, pursuant to Section 165 of Evidence Act, the judge has the power to put questions to any witness to order the production of any documents. So again, if you have no much understanding about Section 165, it's a no-go lah. Okay. This argument is largely based on the case of Ilonita Abayon Chua. Okay, it's a Filipino drug trafficking case against PP. Okay, so proviso of Section 165 allow the judge to descend to the arena of the argument, but not to assume the bench of prosecution. Okay, yes, Section 165 enable the judge to ask question, but he should not presume the role of DPP. Okay, remember this. Situations where a judge may ask question, that is, I make it fast a bit. Number one is to clarify ambiguities. Okay, important, clarify ambiguities. Number two is to fill the gap in evidence. Okay, and number three is to ensure relevance and materiality. Number four is to resolve contradictions during trial. Okay. And number five is to ensure fairness of a trial. You can refer to the case law here. And the safeguard against descending into arena. You must be neutral all the time. You cannot just tilted on one side. Okay. This is again neutrality and impartiality lah. Okay, so there must be as minimal intervention as possible. You cannot simply just ask so many questions. Is it you, the lawyer, or you are the judge now? Everybody is confused. Okay. And subsequently, you must adhere to legal principles like natural justice, that is the right to be heard and there's no bias, something like that. Okay, so the case refer here, if you are interested, but I recommend you not lah. Okay, you can read the Elonita Abayan Chua, okay, against PP, and the roles of judge in civil trial in adversarial proceedings. You can also read this important case, Jones against National Coal Board. Okay, I think, yeah, that will be all for today. It's quite what we call a taxing session.